Good afternoon. My name is Mike Crispin. I'm doing my research around the issue of consent decrees. And the title of it is The Effect of Federal Consent Decree Mandated Training on Police Legitimacy from a Procedural Justice Perspective. In 1994, the U.S. Congress passed what is referred to as the Violent Crime Control and Law Enforcement Act. This empowered the Department of Justice to investigate local police and state law enforcement for issues of complaints relative to patterns or practices of unconstitutional policing. Typically, these came as a result of complaints from the citizens, or there could be a major event like a shooting or something like that would occur that would bring the attention of the federal government or elected officials nationwide on those particular agencies. And then those investigations would lead to potential agreements between the local agency and the federal government. Now, one of the reasons for those agreements is because under our federal system, there's already a little bit of strain between police a little bit of a strain between the federal government and the state as a natural antagonistic system called federalism. And in order to get issues resolved quicker, typically there's a lot of collaboration necessary. And these collaborations tend to result in agreements. We call those agreements consent decrees. Research has shown that while these agreements are in effect now, that these agreements generally are intended to list a series of things of which those agencies and their cities are willing to accept that they will change or they'll make adjustments to. These are things like policy, transparency, and things like body cameras and use of force training. And one of the things that are very crucial in all those consent decrees is a mandate to do training in constitutional law and local laws and things like search and seizure and things of that nature. So what I'm studying here is the effect of this consent decree mandate for police training in the Constitution. And I've chosen to look at Cleveland and Warren police departments in Ohio. Both of them have been under consent decree by the federal government. Cleveland is currently still under it, and Warren Police Department has successfully completed it. So I choose both of them to look at for this study, for this research. The research question here is, how did the federally mandated constitutional training that was outlined in those consent decrees for both Cleveland and Warren influence the understanding of procedural justice relative to the theoretical underpinnings of the Constitution? Now, the theoretical underpinnings of the Constitution is important because there's already research in the literature that demonstrates that police generally do not get a very good amount of training from basic academy level on the theoretical underpinnings of the Constitution. And Dr. Lineski, one of the leaders in that area, has indicated that it's difficult for even lawyers to make a decision on novel situations if they don't have theoretical underpinnings. So how could we expect police to do the same thing under stressful situations and under novel situations if they don't have basic constitutional theoretical underpinnings concepts? And while you may teach them substantive laws, which essentially is what the law says you can do, like speeding, you can't speed. If you speed, they do these certain acts. Well, you may teach them how to police. Making sure they understand why they police a certain way is lacking in the training, according to the literature, at least specifically in the basic academy level. And so the question again asks, how did the federally mandated constitutional training under this consent decree for Cleveland and Warren influence the understanding of the procedural justice relative to the theoretical underpinnings of the Constitution, those two going together? And then it also asks, what was the effect of this training on citizens' complaints to the agency? And it seeks to answer those two questions to add to the body of work on the effectiveness of consent decrees for constitutional policing and mostly for police legitimacy. Now, again, I said this research is led by theory of procedural justice, which procedural justice posits that police legitimacy, and that's the key to this, police legitimacy. which directly affects citizen satisfaction, or in my case, the reduction in citizens' complaints to the agency, which is my dependent variable. It says that police legitimacy is an important factor for improving the notion of constitutional policing and the ability of police to control and prevent crime. Now, what this emphasizes is four things. In a what would be considered police legitimacy would be if the community accepts the fact that their police department or the way they're being policed is fair, that the police are being transparent with their practices, that they're engaging the community so the citizens has a voice in the process, and that they're all treated respectfully. Tyler suggests that police training can alter behavior and improve a sense of procedural justice for the community. So if Tyler suggests that, and you find that in the consent decree as a mandate for constitutional training, then in my sense, my purpose, the research design will engage the theoretical framework that supports this procedural justice concept. And that framework is guided by the social contract and popular sovereign theories. So following that popular sovereign principle of democracy, Terrell and Ingram say that when trust in police is eroded, it results in a perception of unconstitutional policing. So therefore, the consent decree template includes a mandate for police training in the Constitution and relative laws, as mentioned. Now, the hypothesis of this research is that if the Department of Justice mandates constitutional training as part of the consent decree, then this training should influence a stronger sense of police legitimacy in the community. And we measure that by a reduction in citizens' complaints. Now, as I said, the existing research demonstrates that officers lack basic training in the theoretical underpinnings of the Constitution, and that's prevalent in the literature. So the federally mandated constitutional training is intended to address these constitutional principles deficit. However, the literature is lacking in research relative to the specific effect the mandated training has on increasing police officer understanding of the constitutional principles. And most importantly, the impact such training has in improving police legitimacy. So therefore, a gap exists in the literature about how this specific mandate impacts the overall effect of procedural justice and sustained citizen satisfaction. To put it a different way, there's a gap in the literature about how the mandate for constitutional training in the consent decree affects the overall procedural justice taught to the police and a reduction in complaints, which is how I recognize a citizen satisfaction level. So that leaves one asking, how does mandated constitutional training for police officers influence the cultivation of a constitutional police culture or their practice, which would underscore the principles of limited government, social contract theory, civil rights, and popular sovereignty theory, the theoretical framework that supports the notion of procedural justice. And furthermore, how does such training influence the citizens towards what they would consider to be police legitimacy and ultimately reduce their level of complaints or concerns with their department? In my research design, I use Cleveland and Warren police departments, and I conduct case studies and document studies first. The case studies, the document studies are first done. I'm doing a document study on the actual training curriculum that was required by the Department of Justice, looking at when it was implemented, how often is it implemented, is it repeated, what was required in it, is it relative to the four components of procedural justice, and looking for those criteria to then help me develop the second part of the qualitative study involving these two cases, Cleveland and Warren, for interviews with 9 officers from each of those different departments. Now, I recognize that I may not be able to get officers that are currently working there, so I may end up having to reach out and find retired officers that were there when it started, there before, and for a while there afterwards. In his research, Linetsky indicated there were 2 important categories relevant to constitutional policing. First was a requirement for foundational knowledge and theoretical underpinnings of the Constitution. And then the second was an interplay between enforcing the law and protecting civil liberties. And the second is very closely related to this procedural justice theory and bringing police legitimacy to the community. So therefore, in this research design, the independent variables will be the training application procedure. In other words, what did the Cleveland and Warren police departments, when they were instructed to create this constitutional training for their departments, how did they apply it? Did they train everybody at once? Did they train everybody and then make sure there was a process to bring new people in to make sure they were getting trained? And what was trained, and is it relative to procedural justice? Is it relative to those constitutional concepts? So the training application procedure is one. The officer comprehension of the police legitimacy in the constitutional concepts. Do the police understand those concepts? And you get that through the interviews that we will conduct. And then, of course, the implementation of the consent decree itself. So each one of those pieces are independent variables that could affect the outcome of the dependent variable, which is the complaints from citizens. So the training and subsequent comprehension will look to examine individual officer changes in behavior around the procedural justice component. So that's what I'll be looking at specifically at the beginning. Then we'll use an interview that will be guided through relevant subcategories like protector, enforcer, consent decree effects, and so on, to see how the interviewees participate within each assemblage that would be relative to the procedural justice theory. Now, the qualitative case studies will answer the first part of the research design, research question, and then we'll provide metrics that will inform the quantitative analysis for the effect on citizens' complaints. So in the quantitative research design, we want to follow what is referred to as an autoregressive integrated moving average, or ARIMA. It's a quantitative time series approach. Now, ARIMA has been used to study domestic violence calls for police services over 5 American cities prior to COVID-19 pandemic. Now, during that pandemic, there was stay-at-home orders that, to some degree or another, was found to affect domestic violence. And so the researchers here studied that period where, in this case, the dependent variable is domestic violence, the effect on domestic violence. And in my case, it's reduction in citizens' complaints. And the independent variables was the stay-at-home orders. And in my case, it's the consent decree mandated constitutional training. And they studied that before, during, and after using ARIMA, very similar process to which I'm using in my research design. So as part of my research design, I'm going to conduct a document review on Warren and Cleveland police departments, and we're going to interview officers from a qualitative perspective. And then from that, we'll then collect data on complaints for a quantitative analysis. Now, the first thing that will be done is a document review for both of them. This will include requests for public records relative to the training curriculum that was required under the consent decree, as well as complaint data between 2010, 2017 for Warren Police Department, and 2013 to present for Cleveland Police Department, because they're currently still under consent decrees. Then any remaining documents I might need that might be associated with this, the actual consent decree themselves and the complaints, all that is available through the Civil Rights Division of the Department of Justice. So those will all be reviewed, and they'll inform the questions and the narrative surrounding the interviews. The training curriculum, though, is going to be analyzed for components of social contract and proper sovereign instruction that'll sort of help lead me towards those 4 components of the procedural justice theory. The research indicates that there can be 3 different states of what is considered to be constitutional policing in the minds of police, one of them being duty to protect, one of them being duty to enforce the laws, another the duty to satisfy or work with the community or engage the community. I plan to use Freeman's example of diagrammatical thinking to approach the questions that will help to disrupt the process for which the officers perceive the issue of consent decrees and the manner through which it is framed under procedural justice. And they'll all fall, some of those questions, those answers will fall under those three areas. And then those will be juxtaposed with the four components of procedural justice. And this will help be informed by the interview guide instrument. Now, the instrument is going to follow a topic guide model that is used to solicit their experiences, their behaviors. That's supported in the literature as well. The interviews will all be recorded using two devices and transcribed for analysis. And then I'll store that electronically for future reviews. To analyze these transcripts, I'm going to use a team approach to coding. There'll be three people involved, myself as a kind of a supervisor, but I'm also going to pull some volunteers to help me. Someone who has police experience, one who has constitutional law experience. He's a constitutional law professor, and one who has experience as in neither of these areas, so that we can ensure objectivity. I want to sort of acknowledge a couple things. First, since the research proposal theorizes that the social problems surrounding unconstitutional policing may be improved by police training, especially in theoretical underpinnings of the Constitution. And we again observe that through the reduction of citizen complaint, then I would expect some observable implications that would come as a result of that. So here's some observable implications for the dependent variable. As the number of officers that are trained in the department increases, then I would expect that the total number of complaints should decrease. And I would also expect that the greater the mathematical scores of the coded transcripts for procedural justice components increases, the lower the total number of complaints should be for each officer. And the greater the mathematical scores of the coded transcripts for procedural justice components increases, then I should see a lower number of complaints for the individual officers too that are interviewed. For the independent variables, then the implications there will be that the greater the theoretical underpinnings focus of the mandated training curriculum, in other words, how more specifically relative to procedural justice the training actually is, then the higher the mathematical scores will be for procedural justice components. The greater the awareness of the contents of the consent decree, in other words, were they even told there was a consent decree? Are they aware of the consent decree? Then I would expect the more they are aware of the contents of it when it was implemented, then the higher the mathematical scores of the coded transcripts for the procedural justice should be. The one thing this research design acknowledges is that it doesn't account for the impact on citizens' complaints, like the complaint of is it unprofessional complaint? Is it a founded complaint? When an officer was affected by wellness issues, or was the officer just having a bad day? It doesn't account for those things. It also does not control for such things as media or political bias that might be impacting the community as a whole and causing them to make complaints. Further, this research is limited in its ability to differentiate between legitimate citizen complaints and false complaints. And quite frankly, it has to rely upon the agency collecting or getting those complaints to assess those complaints. So it's uncertain as to what effect these issues would have on this study. And to a certain degree, other research has recognized those same issues. However, overwhelmingly, the literature has largely accepted the idea of citizen complaints as an indicator of unconstitutional policing, or at the very least, an indicator of a concern for police illegitimacy. So the strength of this research proposal is that it observes for the level of constitutional knowledge of the officers, which is the mandate, and its effect on citizens' complaints, which is a measurement of citizen satisfaction, and this is indicative of police legitimacy, which falls right into procedural justice theory. This research proposal, it makes an attempt to avoid research design pitfalls by first not selecting cases based upon the dependent variable. Now, while the two case studies are relevant to the dependent variable because both agencies already had a measure of citizen satisfaction that led to the federal intervention in the first place, These studies only observe for constitutional knowledge prior to and following consent decree intervention without inferring anything about citizen satisfaction or citizens' complaints. Now, while the two case studies are relevant to the dependent variable, because both agencies already had a measure of citizen dissatisfaction that led to the federal intervention in the first place, these studies only observe for constitutional knowledge prior to and following the consent decree intervention without inferring anything about citizens' complaints or citizen dissatisfaction. This should prevent the dependent variable from having influence on the independent variables. To avoid measurement errors, the research design analyzes the data within the theoretical framework of the research questions. There may be factors that bias the citizen complaint numbers. These omissions should not bias the observations because they have no influence on the level of an individual officer's knowledge or his tenure within the agency. That's not to say that there exist no omitted errors or variables, as that cannot be said conclusively, but the design method is closely linked to the theory in such a way as to account for uncertainty and potential causal inferences. In summary of the research design, from a mixed methods perspective, the quantitative analysis using the ARIMA model will examine the dependent variable, which is the citizens' complaints or reduction, looking for a reduction in complaints or an effect on complaints, by the independent variables, which was the implementation of training and the periods of those training, whether it's repeated or not repeated. So the independent variable is the actual training itself, and the dependent variable is the complaints. Now, in the qualitative portion of the mixed methods, the dependent variable will remain the complaint or level of complaints, both of the agency and of the individual officers interviewed. The independent variables are the training, the type of training, how closely aligned is that training to the procedural justice components, the knowledge of the consent decree, and their personal backgrounds relative to procedural justice. Each of those will potentially affect the dependent variable. Based upon the theoretical framework, this mixed methods approach to studying the effect of consent decree mandated constitutional training will expose its overall effect for improving police legitimacy from a procedural justice perspective. This research examines the impact of mandated Constitution training for both Cleveland and Warren, and the potentially observed effects could be indicative of similar outcomes in other American cities with comparable demographics and organizational structures, especially the ones subjected to federal investigations for unconstitutional policing. Additionally, and lastly, I believe this research may highlight a potential broader applicability for these training procedures across various police departments to effectively reduce complaints and increase procedural justice nationwide. In light of the many issues and relationship concerns between law enforcement and the community, criminal justice and the community, and government in general and the community, this is an important study with a great deal of political policy implications that could improve procedural justice and the process policies related to procedural justice across the nation. So thank you very much.